Okay, yeah, you had a cord in your hand, so I thought you had one. You need one? Okay, we'll get you one. We'll get you one. You had a cord in your hand of some sort, so I thought you had but you don't.
You gave her one?
You got the headphones, but you don't have the device? Oh, okay. You see, she got the headphones, but she doesn't have the little, you got one of those? All right, we'll get you one in a moment. Anyway, my understanding is all of our jurors are here but one, and the one who is not here had difficulty with transportation this morning. And the way I get the story, Mrs. Winnie actually got the story, but not me, but was this person lives in eastern Pierce County. And you can get a little bit of more difficult or colder weather conditions out there. Hit a patch of black ice, damaged their vehicle, managed to get it back home, but has no transportation to get here, and will not have any for the rest of the week probably until their car is fixed. And they live out in Graham. So Mrs. Winnie immediately volunteered to go out there. Well, I said if it wasn't Graham, I might have done it. Not that there's anything wrong with Graham, but it is about, well, I don't know, 15 minutes one direction from here or so. So it's a little bit distant. So that juror is not here. Everybody else is. As far as I can tell, everybody's feeling okay. So I guess I'm proposing to proceed in the absence of that juror.
Can you tell us who that juror is, what juror number is?
Would it make a difference?
It might.
And the reason for that is?
Well, there's particular jurors that I think that, I mean, there were particular jurors, I think, that came with different experiences that were important to both the defense and the prosecution. I don't think that, I think there may be solutions to this that we may be able to come up with, so I'd like an opportunity.
What do you have in mind?
Well, if it's just transportation, I think that we may be able to secure transportation for the individual.
Well, if you want to provide an Uber or taxi service or something, we could try to contact the juror and see if they're still around. I imagine they are since they've got no car, but they may have gone for a walk or who knows what else they might have done.
Sure. I mean, is this an alternate? Is it someone that's currently sitting? I guess are kind of other questions that we have. So.
Well, I can tell you, I believe it is not an alternate.
Okay.
I'm sorry, I didn't hear the comment.
I believe it is not an alternate. That's my understanding.
I'm sorry.
Not an alternate.
An alternate, okay, sorry.
Not an alternate.
I'm having hearing issues this morning, apparently.
So is everyone of yours. Maybe it's me having speaking problems,
It was a
but
holiday, I don't know, my ears plugged up.
So if we could know who the juror is, I think that could start a conversation on what potential remedies we have available. I mean, at the very least, I think we came up to discuss what there is remedy available.
I'm not hearing a solution yet.
Well, we could send out an Uber. We could have the person come in.
Are you going to pay for that?
I think we could possibly do that, but I need a moment to discuss it with everyone. I mean, this person's dedicated 11 weeks of their time to this case. And it's just transportation. It's something that we can fix. It's not they're sick. It's not that they don't want to be here or can't be here because of some illness.
It could be for the duration of this person's transportation issues.
Understood.
Okay, I'll give you a minute to talk about it. Mrs. Winnie, would you make a phone call to the juror and see whether or not they would be able to be available to come in by Uber? Okay. Yeah, we'll do it in the back. All right. So we'll take a brief recess here for about 5 minutes so you guys can have that conversation. You're assuming it's a her.
They,
You're assuming it's a him. Pick the juror up. Okay. Mrs. Winnie contacted the juror. It's my understanding the juror is willing to continue to participate, but is feeling some back pain, some distress from the incident this morning. So I suppose it's still possible they may not be able to stay with us, but, and that will be potentially for the duration of this unless some other arrangements can be made.
correct.
And you're willing to pay for that. And how are you going to pay for it this morning?
We just need the location.
You can order, you can put on like a credit card or something?
Correct.
Okay.
Just put it on my Uber account and order on my phone.
I don't think it's appropriate for the juror to know that, or to find out that the defense is paying for them to commute in. The state's position is that we should just go forward with the alternates. That's why we have alternates. Obviously, the last juror who came down with COVID, the court excused, and she too had been here for 8 weeks. So we don't see any reason not to, that's why we have the additional alternates, is just to move forward. And it sounds like this juror had a traumatic event anyway this morning,
Yeah, I'm not sure how traumatic, but yes.
having some pain, and I'm sure taking your car out of commission is not an insignificant thing for somebody who lives further out too, so.
We certainly don't need to disclose who's paying for it. You can just say the court's willing to provide transportation.
No, and I know Mrs. Winnie reminded the juror to continue to not watch anything with respect to this case. So, if we do this, we're basically blowing the morning.
We have Mr. Nielsen here. He can wait, it's not a problem. We can start at 1 o'clock with him. And then go start with the schedule. It's no problem. And we're anticipating, I mean, the defense is anticipating that if we can get done with Nielsen, we're gonna call Asa Lewis, the toxicologist. And I think that we'll be able to put on our case and rest by this week. So it's not a huge amount of time in terms of how much case we have left as well.
On that front, Your Honor, we would ask what is remaining, because we were told that there were 5 witnesses scheduled for Monday and Tuesday, and I wrote repeatedly to the defense this week and over the weekend asking to confirm. And it's my understanding maybe this morning that the people we were told they were calling, they're not calling, and that they may not be calling anybody after Mr. Lewis except for their clients. So I think the state just needs to know what the status is, because obviously we prepared for other experts that we were told were coming, and Officer and Sergeant Sanders, and apparently those may not be happening, so.
Can you answer that question for us, Mr. Conrad?
I mean, obviously, trial's a dynamic situation. If the testimony comes out the way that we would hope it comes out, or that we expect it to come out, there may not be a need for certain individuals to testify. It happened during the state's case as well. We prepared for witnesses, and they didn't end up testifying as well. It's just part of being a trial attorney.
I don't think we ever disclosed anybody and then called them. We were told Levine was coming for today and that Sanders was coming for today/tomorrow. And that there were more experts with respect to, or more witnesses with respect to medical records. So we just want some clarity so that all parties can be prepared if we're gonna rest this week. Who else is coming?
Can you tell us that?
Well, yeah, certainly. So we have Nielsen today.
Right.
I think we can get the juror transportation in this morning, and we start with Nielsen as soon as the juror's here. Then we'll next call Asa Lewis to the stand. And then we wanted to break and discuss as a trial team whether we need to call Dr. Levine, who's a toxicologist out of UCLA, or any of the other witness officers, or if we're going to call our clients next.
Or if we're gonna call who?
Our clients to the stand. As well as records custodians. I still need to, I owe Ms. Eads an email with regard to some records that are seeking either a stipulation to their admissibility, some of the medical records or mental health records. All records custodians.
So in terms of tomorrow is, I mean, we're now 24 hours from tomorrow, so we're looking for who's gonna get called tomorrow, obviously.
Well, I'll let you guys talk about that amongst yourselves for just a minute. I'm going to ask Mr. Gaddis to come back, and we'll be back in just about 5 minutes. And Susan, come back. gonna lose too much time. Although my understanding is the location is probably not as far as Graham. It's sort of eastern span away, let's put it that way. So it's not quite as far away, but it's still probably about a 40-minute drive at least in each direction. So I'm going to proceed. And I'll direct Mrs. Winnie to let that person know. I'm concerned about, I think it's problematic that one party pays to have a witness or a juror to be here. There's been some discussion about Pierce County being able to somehow provide a way to get here, but they had not figured out that yet. If I gave them more time, maybe they could provide something for us, but I don't know. If the defense is really gonna rest this week, then I've still got a couple more alternates, and we should be okay in terms of getting the trial done, I would think. So, we're gonna proceed.
Your Honor, to the extent we need to make a record, I guess I just note our objection or present on behalf of our client.
Same objection.
Okay. Do I have to say it out loud? Objection's overruled? Okay, well, as soon as we get a break, Mrs. Winnie's going to advise the juror. Or once we get started, if you have a chance, go back and advise the juror. Okay, is Mr. Nielsen available?
Your Honor, take a stand.
I would say we can have him come on forward, and then let's have the jury back. Well, let's hope that the tryptophan is worn off by now, and you're all alert. And we can resume with the direct examination of Mr. Nielsen by Mr. Fricke. Mr. Fricke, when you're ready.
Thank you, Your Honor. Good morning, Mr. Nielsen.
Good morning.
Going on 2 weeks, I think, since you've been here. My recollection, where we ended off that last Thursday before, the week before Thanksgiving, we had gone through principle of parsimony and the transition before force options. One of the things I wanted to ask you about, and backtracking a little bit, is the concept of necessity. And what is that, number one?
Well, police officers are trained that necessity, when it comes to using force, is defined by statute. So there's a law that we're all trained on that defines what necessity is.
And when you talk about that in the context of the training, what do you look at specifically?
Well, actually, at the police academy, it's such a fundamental principle that we're all trained to memorize it. At least when I went through, you're trained to memorize the definition of necessity because it's such a fundamental principle in police training.
And what do you focus in on? If you're under the stress of the event, what are you looking at?
I think it would help to define necessity.
Okay, on the law. And the court ultimately will instruct the jury on the law, of course.
Yeah, understood. But as a training principle, it's important for how police officers make force decisions and manage force events.
Right. And so do you consider the risk at the time?
Yeah, among other things, yes.
Okay. And what else do you consider?
Whether there are any reasonably effective alternatives. I mean, I think it would help to define it
Okay, go ahead.
if I could, yeah. So the definition that the police officers use, which, as I said, is codified in a statute, is that no reasonably effective alternative to the use of force appeared to exist, and that the amount of force used was reasonable to effect the lawful purpose intended. And so we could parse that down into smaller components because it's kind of a jumble, but.
And please do.
So you start out with no reasonably effective alternative appeared to exist. Okay, so that means that in the world of police work that there are typically many things the officer could do, but that's going to depend on the officer's training, knowledge, and experience. And so you might evaluate the force options in the context of a particular officer knowing what that officer knew at the time, not only about the event, but that officer's history, what they bring to the event as well.
Okay.
And that's how you get to a force option that may appear to exist to the officer. Because once you, in hindsight, analyze the event, you may come up with a variety of options that could have happened, but then the officer may not have either had the equipment, may not have had the training, may not have considered that under the circumstances.
And again, we don't use hindsight, is that correct, based on your understanding of the law?
Correct, and we'll get to that with the later part of the definition.
Okay. And then, so the second, or the next component would be what?
Reasonably effective alternative, and the amount of force used was reasonable to effect the lawful purpose intended. So then you look at the amount of force and then the reasonableness of that force. And that's when, like the Graham factors that we discussed, come in there.
And that goes to, well, we'll go to, and what's the next component of it?
Well, then the lawful purpose intended. And so broadly speaking, you look at what was the officer trying to do at the time? Was that legal? And what were the circumstances under which those decisions were made?
And when you look at the circumstances, when the decision was made, you're talking about the time of the event.
Correct.
And that's do you consider that an objective or a subjective determination?
The analysis itself is objective, but it has a subjective component insofar as you're putting yourself in the officer's shoes at that time of the event.
Go ahead.
So for example, like an easy way of looking at may be, I mean, we could discuss it in broad terms or in terms of this particular event.
Let's do broad terms at first.
Okay, So, for example, if you had a 25-year officer, right, who maybe was a SWAT trained officer, those officers tend to have a higher degree of training. Maybe that officer had a prior career in the military or maybe in medicine or other knowledge that they bring to the event. Maybe that officer has been involved in a variety of similar or even dissimilar use of force events. So you might look at, for example, fighting with someone under the influence of drugs. If that officer had a similar experience, right, and knowledge based on that experience, you would factor that in as well. At the other end of it, you might look at like a very new officer or a probationary officer who doesn't have that same experience, right, doesn't have that same level of training, and you would evaluate the force in that context of what that officer knew at the time in their training and what they were trying to accomplish.
And then you, specifically to this instance, what did you consider?
Well, both the career duration of both the officers, all three officers actually, but when I was looking at many components of the force event, like for example, Officer Collins, I know has a fair amount of training related to like grappling and ground fighting. And so when I looked at some of the force options or the manner in which he was exercising force and trying to control Mr. Ellis, in the context of what he knows and his skill set, I was able to look at that force in that same context. And the same with Officer Rankine and then also Burbank as well.
Okay. And when you look at, and you mentioned not the other day, a couple of weeks ago, almost a couple of weeks ago, that you found that the force used by the three officers here was reasonable, both individually, correct?
Correct.
As well as collectively?
Correct.
And how did you reach that conclusion?
So when you look at force events, and like I said, I alluded to the last time that we were together, was that the reason that police officers are judged on a reasonableness standard, and that there's not a manual that you open up with a flow chart of how things go when you're dealing with force options. It would be much simpler if there were, but these events are so dynamic and unpredictable that that's why it has to be a broader lens of reasonableness, right? What they were trying to accomplish and under what conditions. And so you have to look at the way that the event unfolded, and what they were trying to accomplish was obviously to detain or to arrest Mr. Ellis, and what they were doing to affect that objective.
All right. And part of that, of course, is looking at their training, as you just mentioned,
Part of it, sure.
and the policies that they're supposed to follow,
Yes,
the particular agency.
yes,
And I think you indicated, again, a couple of weeks ago, that you had looked at the Tacoma training manual for police officers, is that correct?
yes.
Okay, and would that be helpful, at least in discussing what the officers were doing here in the context of what was included in that manual?
Yeah, both helpful and appropriate.
Okay. And so if I could have exhibit, just not for publication, but to show Mr. Nielsen, exhibit number, I had it, but I believe it is 3.
Right up there.
Yeah, it's here. It's 300. I think it's going to pop on your screen, but again, it's not for publication.
I see it.
Okay. And do you see section 3.1? Is that in front of you?
It's not, you'll have to scroll, actually, yeah, it's way down. This is just the early stages.
Yeah, no, it's a different one though. So
This is not the right section.
3.1 in front of you?
Yes, this is the first page of Tacoma's use of force policy.
Now, if you look at the very last paragraph on that subsection, do you have that?
Yes.
And that's something you reviewed in the context of this case, is that correct?
Yes.
There's a concept called controlled superiority. You see that?
I do. Together, we talked about proportionality, right? And we discussed how when you're overcoming resistance of the person you're trying to detain, you have to come up with a little higher force than what you're being offered. That is to overcome their resistance. And Tacoma's policy defines that, or they use the term controlled superiority to describe that concept. And actually this paragraph directly addresses that concept. And controlled superiority basically, as we talked about last week or whatever it was the week before, that when you're making force decisions, you have to gauge the amount of force that you use based on the resistance that you're getting from the person, and then come in with enough force to overcome that resistance.
Right. And if I'll move for the admission for illustrative purposes, this exhibit number 300, Your Honor.
Did we have this in another exhibit?
It was in another, the exhibit, there's another exhibit up here, but it doesn't have 3 point, at least the one I see, 3.1, unless there's another one that I forgot about.
I think there is,
We,
but not 300.
Not 300, it's 301, I think.
301? That could be.
that's my point. 301 does not have that particular.
Your Honor, the state would object to the entirety of 300 being admitted. 300 is, I want to say, a couple hundred pages long, versus he's looking at a section that's over 12 pages.
Well, for the record, this,
Well, 301 was admitted for illustrative purposes only. And I don't know whether or not it's in this or not, but
301 is not contained in the section that he's reviewing.
correct, 301, the section that we're reviewing in 301 was not contained, or excuse me, in 300, it's not contained in Exhibit 301.
all right. This looked similar to
Mr.
something
Clerk,
I've
if
seen.
you want to offer pages 1 through 12, base stamped 1504 through 1515 as an excerpt from Exhibit 300, the state has no objection to that for illustrative purposes. If that's what you're,
That's no I have no problem with that. I'm restricting it to those pages.
What were the pages again?
They would be, on this particular exhibit, pages 1 through 12, date stamp 1504 through 1550. Do I have that correct?
1515.
Yeah,
So it's only subsection 3.1.
correct.
For illustrative purposes. And I take the state as no objection based on the prior comments, so 301, subsection 3.1, use of force, pages 1 through 12, is admitted for illustrative purposes only.
Yeah, I don't know if I'll have to eventually remark that as 300A, but whatever, however the court wants that done. So, but those are the pages. So if we could,
Just for clarification, I think the court said 301.
yes,
It's subsection 31. 301 is a different exhibit.
correct. This
Right,
is
no,
300.
if I misspoke, I'm sorry, but I meant to say subsection 3.1, use of force of exhibit 300.
Correct. That's correct.
We'll call it 300A.
I can do that. It's-
Maybe.
or-
Mrs. Winnie will let us know. Mrs. Winnie will let us know.
Okay. However you want to do it, but we'll get it marked whenever we need to do it, so.
And for illustrative purposes only.
Correct.
Okay, so 300A will be admitted for illustrative purposes only.
Yeah.
Okay, that's all I need to know.
Okay, thank you. And we'll get that. If I can have that published, that first page we've been talking about here. And again, and I don't know if you can focus on that bottom of that particular exhibit page. And that's under the force model, obviously, correct?
Yes, and Tacoma has this graphic depicted here in the middle of the page. There's a few of those throughout the policy, and they go as we talked about, kind of intro, intermediate, and then deadly force earlier. There's one of these graphs for every level that they characterize in their policy. But yes, the bottom of the page is the concept we've been discussing.
And that's the controlled superiority.
Correct.
And I from last week, you describe that again, what that means, how you were explaining it a week ago.
So, yeah, I think the example that I used last week is if for example, a person, slaps you in the face, and that's the resistance that you get, and then the officer elects to slap them back, and then the person slaps the officer again, and the officer slaps the person back, you essentially just end up with two people slapping each other until one of them either fully passed out or otherwise gave up. And that's just not a viable way of taking someone into custody. So, for example, if someone slaps you, you might strike them or tase them or take them to the ground. But whatever the force, the resistance that you're getting, you have to come in a slight degree higher than that so that you're successful in detaining that person. Otherwise, you're just beating each other up, right? Or if you come in too low, then the officer would lose and suffer much more serious outcomes.
And then when you're using force, I mean, you're under this at the event itself. Obviously, there's stress going on. One would expect.
Well, yeah, and not only that, but officers are restrained by the types of force that they can use, whereas the people that you're dealing with aren't.
And you're constrained by policies that are developed either through the Graham factors or otherwise, correct?
Correct.
And the other person is not.
Correct.
So, and in the context of that, and also what you discussed a week plus ago, you indicated, I believe, the concerns of the officers basically are threefold as far as protection aspects go, correct?
Yeah, the life safety priorities, I think, is what you're referring to.
Correct. And then the first one is?
Officers are trained to, when you're making decisions, whether they're tactical decisions or force decisions, the first consideration is the safety of uninvolved people or the general public. And so when any police response should necessarily prioritize the safety of uninvolved people and the general public.
And the second one is?
The officer.
And the third one is?
The person with whom you're dealing. Typically the suspect.
All right. And when you are using use of force, or you're in the context of the use of force, obviously, well, I don't want to put words in your mouth, but the force you use, again, depending on the situation.
Correct, always.
And the last use of force is lethal force.
That's the highest level of force, yes.
And lethal force would include what?
The most obvious example would be a firearm. Some less obvious examples might be, for example, hitting someone with your car would obviously be a lethal use of force. If you're using a baton, for example, strikes to the head would be considered a lethal use of force. But it's defined as lethal force is force that would cause death or substantial injury to the person, reasonably foreseeable.
Okay. And the taser, again, is not included in that, correct?
A taser is not lethal force, typically, no.
And when is it appropriate to use a taser?
That's kind of a broad question. There's a variety of circumstances under which a taser would be appropriate. In the arc of law enforcement, the taser technology is relatively new. Now, it's been around for many years, but in the arc of the profession, it's a fairly new technology. Like any technologies, that option has evolved over time. And so the circumstances under which you would use the taser when it was first introduced has shifted a little bit, and now it's a little bit more restrictive. But typically, you have to be experience a relatively moderate to moderate high level of force to justify taser use.
Okay. And like if, in the situation here, were they justified, was Officer Burbank justified in using the taser?
At the time he did, yes.
Okay.
I believe so.
And so let's talk about the event in question then. And when you say at the time he did, Like if he had just got out of the car and tased the guy right away, would that be appropriate?
Well, maybe under this circumstance it may have been.
Okay. Well, let's go through the circumstance. And what do you consider the beginning of this situation here?
Well,
March 3rd.
I mean, the beginning of the encounter, my understanding is that the beginning of the encounter occurred when Officer Collins observed Mr. Ellis interacting with a passing vehicle in the intersection that they were at. And at that point, my understanding is that Officer Collins called out to Mr. Ellis to get his attention to figure out what was happening.
And so, and then it continues to transition throughout this situation here.
Yeah, and I know, we talked earlier about force as a concept and how some people characterize force as officer presence. I would say that when Officer Collins spoke to Mr. Ellis, that was not a force event.
Okay.
I think that he was just at the beginning investigative stages of trying to figure out what he's seeing, what's happening.
When do you think it evolved into a force event?
I think that once Mr. Ellis approached Officer Burbank's window on the passenger side and said something to the effect of, "How about I punch you in the fucking face," or something like that, and then began striking the car. I think that was the onset.
And that's from Officer Burbank's statement, correct?
Correct.
Okay. And I think we were just starting to talk last time about the inconsistency of some of the statements here from Officer Burbank and Collins, McDowell and Lowry, White, now Mailing, and Cowden primarily.
Yes, there
At
are.
the beginning of this, what people perceive to be various stages of the beginning.
Yeah, there are divergent accounts of the event for sure.
And did you take those divergent accounts into consideration in formulating your opinion?
I did.
If you had to resolve certain things, what did you use from the event itself to, come to a conclusion as to what happened, if you did?
Well, like we discussed briefly, I think right before we broke last week or the week prior, is that it's not uncommon to have disparate accounts of the event. And that could be for a whole host of reasons. It could vary on where the person was looking when they saw what they think they saw, right? It could account for the novelty of what they're seeing. If they've never seen that kind of thing before, it's going to take some cognitive effort to process that meaningfully. The environmental conditions, the lighting, right? The level of stress, a whole host of factors could come in when people are perceiving events and how they later recount them, right? And so it's not uncommon at all to have disparate or divergent descriptions, not only from witness to witness, but between officers as well. And there's a whole host of reasons for that. And when you are trying to just figure out what happened from a third-party perspective who wasn't there, and this happens in detective work all the time, you have to come to some fundamental understanding of the event, is that you look at the statements of the witnesses in the context of the objective evidence. That is the evidence that we would all have to kind of agree on, right? And that could be video, photos, physical evidence like items that were left at the scene, those kinds of things. And I think that the description or the example that I used last week is that if you have a shooting, for example, and one witness says, "I heard 10 gunshots," and one witness says, "I heard 2 gunshots," right? And there are 10 shell casings at the scene, and the person has been shot 10 times, then on a more likely than not basis, you would say there were probably 10 gunshots, and the 2 gunshot account would probably be discounted on that particular issue. So when you're trying to figure out how many gunshots were fired, you would probably take the 2 gunshot person and put that aside and say, "I'm going to go with the 10 gunshot theory," because that's corroborated by the physical evidence.
And in this case, there were no gunshots, of course, but we had taser applications.
There was a taser application.
And you recall the number of taser applications that Officer Burbank gave in his statement?
My recollection is that he believed he used the taser more than he actually did. And I think he said 5, and I think that objectively it was actually 3.
And objectively means you looked at what to get to that number?
Well, so the taser has an onboard processor, so you can plug the taser into a computer, and it will give you data on the taser. So it will tell you how many times the trigger was depressed and for the duration. And so that's objective data that it would be hard to refute. And so even though Officer Burbank said it was 5 times based on his belief during the stress of the event, we know that it was actually 3 times because we have objective data that verifies that. And that's an example of what we were talking about, is that he's, for whatever reason, under the stress of the event, he recalled or he believed that he used the taser, deployed it 5 times.
And that's not unusual.
That's not unusual, no. And that happens with gunfire, with strikes. The police officers are human like everybody else, and under stress, they misperceive things.
Okay. Now, as far as Mr. Ellis coming to the door of the vehicle that you just mentioned a moment ago, where did you get that information? Did you get it from statements and objective evidence, or one or the other?
Well, my understanding is that everybody essentially agrees that Mr. Ellis rather was at the door with Officer Burbank at some point in time. So his proximity to the car is kind of there's a consensus around that.
And did you also, to confirm that, use any objective evidence?
Well, I know that Officer Burbank indicated in his statement that he believed that Mr. Ellis was carrying items at the time, although he was unclear on what they were. And then later we learned that he did in fact purchase items at the 7-Eleven, which was some water and a box of donuts. And through objective evidence, that is the photographs, there was a box of donuts at the base of the passenger door of the patrol car they were in.
And you're referring, and if we pull up exhibit number 2732, and I do believe this was previously admitted. but I'll just check. Yes, that was admitted, so we can publish that, if I may publicize that, Your Honor, or publish it.
I'm sorry, give me just a second. What was the exhibit number again?
2732. Excuse me, yes, that'll be the first one.
Proceed.
And is this one of the exhibits you looked at?
Yeah, this is one. This is not the box of donuts that we were talking about, but this is another photograph that I looked at.
Yeah. And what did this, for your purposes, what does this confirm, if anything?
Well, for example,
Objection, Your Honor, on the, it's basically going through the credibility of it. If he wants to rephrase the question.
I'll allow the question. Go ahead. How did this impact your analysis of things?
so the beginning with, there was a box of powdered donuts at the base of the passenger side door, right? And that's essentially irrefutable. There's a photograph of that. It was there. Then Officer Burbank stated that Mr. Ellis had punched the passenger side window of the car several times after saying, how about I punch you in the face, or however he phrased it. The box of powdered donuts that was being held by Mr. Ellis with the white powder on the window, I inferred that that was consistent with Officer Burbank's statement. And also the fact that it was
Yeah, I'm gonna object at this point. His inferences consistent with, it's all invading the province of the jury for credibility determination.
Overruled. You may answer.
You can continue unless you're finished.
No, and further, the investigator who responded to the scene also, he or she photographed this also, and so it has evidentiary value. So the fact that the photograph exists in the first place is also telling to me that the person investigating it took note of that fact as well.
And then, I think, if I'm not mistaken, show him, well, this one has not been admitted yet, but if you can show him, without showing the jury, exhibit number 2674. You have to see that in front of you,
I can see it.
and that's something you look at in the context of this case as well, that particular exhibit,
Correct.
and that shows what?
That's the box of powdered donuts at the base, basically the foot of the passenger side door of the patrol car.
Your Honor, I move for the admission of exhibit number 2674.
I believe there's another exhibit of the same that's been testified to.
I actually believe there is two, but I just
Yeah.
don't remember the number.
Hold on a second.
Check here.
Try 159.
159, show 159. Thank you, Your Honor.
I'm not sure if this is right, but try it.
This has previously been admitted. And that's what you're, the same, this is a blow-up, but the same exhibit, correct?
Correct, that's a closer perspective.
Yeah, and this is 159.
It is correct, you're
Okay. And 159 was previously admitted.
correct. And how does that influence your ultimate conclusions, these particular exhibits?
And so when you have, like I said, divergent theories of what happened, you have essentially the McDowell, Lowry, kind of to a lesser extent Cowden theory of the event, and you have the officer's version of the event. What,
Your Honor, again, I'm gonna object to response to this line of questioning with it being, he's not opining on use of force. He's not opining on police practices. He's opining on credibility of witnesses.
Well, as I understand it, in order to comment on the use of force, he needs to identify what are the facts that he is basing his opinion upon, and I think that's what this foundation's about. Have I got it correct?
That is correct.
So I'll permit it.
And if he, if I may, Your Honor, if he says, I base my opinion on the defendant's accounts, the officer's statements, then that's fine versus going through and.
Well,
I'm not
it would
saying-
be fine to say, if it's fine to say he could base it on the officer's statements generally, then it seems to me he can talk about them specifically and talk about it too. So, overruled.
So you utilize this, this photograph as well as the other one that we so far have looked at in formulating your opinion?
among other things, yes.
Among other things. And what's the importance of this particular photograph in the context of your opinion?
Well, because there are factual disputes underlying the event, this, to me, this gives me a foundation upon which to conduct the analysis. If there were objective things that were wildly inconsistent with the officer's account of the events, then it would be a much different analysis, right? But what I'm looking for is kind of a convergence of the statements with objective evidence, or opposite, a divergence of statements with objective evidence.
Okay. So you, by utilizing this and other photographs with the, well, for instance, the last photograph that showed the powder on the window,
Correct.
that's never been analyzed to your knowledge, is that correct?
Not to my knowledge.
And have you come to a conclusion that it's more likely than not powdered sugar from a donut or
That,
something from the donuts?
well, in the context of the statements offered by Officer Burbank, in the physical evidence, that is the powdered donut box at the base of the door, and then there's a powder on the window. Like, there's convergence there.
And the purchase of the items at the 7-Eleven?
Yeah, correct. That Mr. Ellis had purchased them just prior to this encounter.
And there's no indication it could be any other thing, is that fair to say, based on what you've reviewed?
Yeah, there is no indication.
Okay. This might be simplifying it, but if it walks like a duck, it quacks like a duck, it's
Objection.
probably a duck.
I'll sustain that objection.
So, there's nothing to believe that you've seen that it's going to be anything other than the powder from the donuts. Is that fair to say?
Well, yeah, no, and I mean, yes, it is fair to say, rather, when we talked about parsimony, both earlier this morning and then last week, that this is kind of exemplifies that principle, right? I mean, there are times, for example, as a police officer, you might go to, let's say, a single vehicle collision into a pole, and you get there.
This is to the narrative.
That's an
and
analogy,
responsive.
but-
He's already answered it.
I'll permit the witness to continue. Overruled.
You go to a single vehicle collision into a pole, and you get there, and the person is stumbling around, slurring their words, there's beer cans everywhere, and they reek like alcohol, right? I mean, there's one common theme that runs through that series of events, and that's the person's probably drunk and crashed their car. Now, you might get the person was diabetic, they recently purchased the alcohol, the crash caused the beer to explode, and it splashed all over them. So you have all these assumptions that you could bake into this for an alternate explanation, but at the end of the day, typically the assumption or the theory that requires the fewest of those assumptions tends to hold true. And so that's both an investigative principle and a principle that I use when I'm looking at cases like this.
Now, when you got this box, well, ultimately, there's a progression of use of force here that you discussed last week.
Yes, yes.
Explain the progression, and well, you watched the videos, is that correct?
I did.
How many times?
Lots.
Lots of times.
Yeah.
And in the statements and watching the videos, did you see a progression of force that was applied by, beginning with Officers Burbank and Collins in the context of the attempted arrest of Mr. Ellis?
I did, yes. And my understanding is that there were events that occurred before the videos that were not captured on video. And so I took that into account as well.
Okay, so describe, and did you feel the progression that was used by the officers was appropriate and reasonable in this situation?
I did. And what I saw was several force options that were ineffective, that failed in what they were trying to do. And so,
Bring that to the jury.
so if you parse it out according to the officer's statements, I think you could say the first reasonable force, let me rephrase that, the first force that was used, which I found to be reasonable, was that when Officer Burbank struck Mr. Ellis with the door of the patrol car. And I think that is, there's a consensus on that event, right? And I think that there's some divergence on why that happened, but objectively, I think that we all agree that that happened. And Officer Burbank explained that he did that because he was concerned that Mr. Ellis was going to had oriented his attention toward Officer Collins, who by then had exited the vehicle, and he was afraid that Mr. Ellis was going to attack Officer Collins, and so he struck him with the door. That's the first force that was introduced to the event.
Okay, and then, and by the way, is it appropriate to get out of the vehicle as opposed to staying in the vehicle when you're encountering an individual?
Well, I mean, as a general principle, the answer is it depends.
Mm-hmm.
And so there are times, typically you want to get out.
And is it a safety issue?
It can be, for sure.
Okay. And how so?
You can't really defend yourself from inside your car. There are far fewer options to defend yourself, absent shooting or tasing or projectile type force options, but you can't fight back because you're confined in your car.
And certainly tasing, it wouldn't have been appropriate to tase at that moment. Is that accurate?
It would depend.
Okay.
It would depend on the justification for that, what the officer explained and what was going through the officer's mind at the time.
Okay.
So maybe not.
Okay, so you have the door knock or nudge, however you want to check, whatever you want to call it, and then you find that's appropriate.
I do, and that's one of the things that you wouldn't find, for example, in the Tacoma Police Manual or any other policy manual, that force option. And so when you talk about reasonableness, right, there are things that don't go down, they're not checklist type options. And so striking him with the door, you say, okay, well, what were you trying to accomplish? Was that lawful, right? And is what you did reasonably related to that goal? And so what he was trying to accomplish was to protect Officer Collins from being attacked. right? And so striking him with the door, which is a pretty low-level use of force to achieve that lawful objective, I find that to be a reasonable tactic under those circumstances.
And even though that's not necessarily taught, but the manual itself, the Tacoma Police Manual, that same subsection indicates, you read that, where an officer can go outside their training if they feel it's necessary under the circumstances.
And that's what I talked about. These events are so dynamic and so kind of unpredictable at times that in almost every policy, there are provisions that account for novel situations that you haven't encountered and trying to figure those situations out kind of on the fly. So you're given a variety of tools as a police officer, and you have to apply those tools in oftentimes novel situations.
Okay. Okay, so we got the door check, and then in your analysis, what's happening next as the use of force continues?
Well, that was ineffective,
Okay.
right? And so, again, if we talk about proportionality and if the opportunity availed itself, I suppose Burbank could have hit him again and again and again and again with the door, but that doesn't make any sense for what you're trying to do. That would not be a viable tactic to try to stop or to try to detain Mr. Ellis under those circumstances. So it didn't work, and it didn't seem to dissuade Mr. Ellis from his efforts to attack Officer Collins. And so at that point, my understanding is that he actually did charge Officer Collins and make contact with Officer Collins.
And that comes from Officer Collins' statement?
Mainly, and I can't remember if Burbank made similar statements or not, but I know Officer Collins did.
And so then, what types of use of force, just go along on the continuum here that you saw in the order that you recall seeing them and coming to your conclusion?
And this is what I'm talking about as far as gram factors go, right? The situation is evolving. It's not static. And so it's becoming more concerning as it progresses. And so when when Mr. Ellis turns toward Officer Collins and Officer Burbank strikes off Mr. Ellis with a door, that doesn't have any effect, and Mr. Collins still aggresses toward Officer Collins. And now you, in context of the gram factors, right, the seriousness of the offense, you have at minimum the potential for an assault on a police officer, right? There's a risk factor there that could injure the officer on scene, right? And so you talk about the seriousness of the offense, the risk to the officer, that's present, and then his efforts to flee or to avoid capture, he's actively fighting. And so this is the balance that has to occur in real time while this is happening.
Okay. And so what uses of force do you see
And so
by the officers?
my understanding is that when Mr. Ellis encountered Officer Collins, that Officer Collins is a fairly, fit guy. I think he weighs over 200 pounds with his gear on. He's probably closer to 220 or 230. And he stated that with very little effort, or seemingly little effort, Mr. Ellis was able to pick him up and kind of drive him back and throw him on the ground. And so now at that point, that's a pretty, from the officer's perspective, that's a pretty frightening occurrence. Okay, and we talked about the taser use. I think at that point, you could have started contemplating taser options at that point. So intermediate, higher levels of force, other than just, for example, verbal commands, or, the policy contemplates things like wrist locks or joint leverage. Those are things that are out of play at this point because the level of risk to the officer is higher than that.
And so striking him, would that be inappropriate?
Yeah, no, it wouldn't be. No, not under those circumstances.
And trying to get him to the ground, would that be inappropriate?
Getting him to the ground would probably be one of the most effective options to detain him.
And were they able to do that right away, based on what you reviewed, watched?
I mean, I know that they went to the ground, and I don't know, I think ultimately it ended there. I don't know to the extent they caused that to happen, but in any event, it ended up on the ground, as these things almost often always do.
And then, as far as the continuum goes, what do you see next happening?
I know that on the video shows, and I can't recall if it's Collins or Burbank that was striking Mr. Ellis, but it was an officer standing over Mr. Ellis while the other officer is on the ground, kind of grappling with Mr. Ellis, and one of the officers is striking Mr. Ellis a handful, 3-4 times, I think.
And that'd be a hard hand as opposed to soft hand, or vice versa?
I assume it was hard hand. I don't. Those didn't look like open hand slaps to me, and that probably wouldn't have been effective
Okay.
at the time.
And then, but again, appropriate?
At that point, yeah, that seems to be a pretty dynamic, aggressive encounter, and so you wouldn't obviously pummel somebody into submission, but 3-4 handful of strikes like that, and what you hope is that the person becomes defensive instead of offensive, and so if you strike the person 2 or 3 times, what you hope to happen is that they start to cover up and not fight back, and so that allows you more force options. At that point, you can start to decrease the level of force away from strikes.
Decrease the level, assuming you get them under control.
Assuming that they react favorably. So if you strike the person 2-3 times and they start to become defensive or turtle up, right, you would no longer, strikes at that point would no longer typically be justified.
And did you see him cover up at this, based on your review of the video?
It seemed like the strikes didn't have any impact on Mr. Ellis's aggression.
And so the continuum continues, and then what do you see next?
I mean, there's a variety of things that are happening. They're wrestling around on the video. And what I'm talking about initially is the McDowell video. Sorry, the McDowell video, and that's the one that kind of shows the strikes, and then the officers wrestling with Mr. Ellis on the ground. And then if you go to the Cowden video, that's the one where you can then see Officer Collins grappling with Mr. Ellis, trying to control him. At that point, he tries to LVNR him, which doesn't seem that it didn't work, and he wasn't able to get it.
And how would you know if it was successful, an LVNR application?
Well, the onset of the LVNR is roughly 7 to 9 seconds. So it takes 7 to 9 seconds, give or take, to get someone to basically pass out. And the mechanics of the LVNR is it basically restricts blood flow to the brain, and it causes the person to lose consciousness. And then they wake back up, and that takes about 15 to 20 seconds for them to wake back up. And they're typically very lethargic, kind of disoriented, out of it. Oftentimes people wet their pants when you LVNR them, and it's because they just kind of shut down and they come back. And so if it was an effective LVNR, it would be obvious. Like the thrashing and moving around would have completely abated for a period of time. And that allows them to then handcuff the person while they're still kind of coming to or while they're still out.
And for a period of time, you're meaning 15, 20 seconds you're talking about? Or?
It would be obvious, yes. It would be plainly obvious to anyone watching the video that now the encounter would essentially be over if it was effective. It wouldn't be where they just kind of nod and come back. That's not how that works.
All right. And that's objective evidence, is what you would expect from a person successfully applying the LVNR.
If it was successful, it would not look like what the video showed.
All right. And so you see that attempt. Do you see any evidence of choking in this video?
No.
And then what's, as the force, that's unsuccessful, then what do you see? And what do you concern yourself with?
Yeah, one of the things that was important to me was that, I know from reviewing Officer Collins' records and from his statement that he has a grappling background. He's wrestling or jiu-jitsu type background. And so without even having spoken with him or knowing anything about his background, what I'm watching him do is very consistent with that. He's trying to capture Mr. Ellis's hips with his own legs. So I have similar training, probably not to the same extent. I've wrestled through my whole life, and so it was very, very clear to me he was trying to capture Mr. Ellis's hips, right, at the same time trying to apply the LVNR. And so when you watch the video and you see Officer Collins' legs kind of sweep around Mr. Ellis's hips and hook in, right, to me that shows that's a skill that's kind of beyond the baseline average level of training that officers get. So the fact that he was having such a difficult time controlling Mr. Ellis, to me, kind of indicated the pace of the event was very high. The resistance was very high because Officer Collins, with his background, was having difficulty controlling Mr. Ellis.
And so, and then you're, and Burbank's still there as well. And then what do you see next? being an appropriate response to that unsuccessful endeavor.
Yeah, so at this point, the Dortch check was unsuccessful. At this point, the strikes had not worked. The LVNR had not worked. Officer Collins' attempts to kind of subdue Mr. Ellis by capturing his hips and grapple him, that had not worked, right? And nothing had really slowed down Mr. Ellis's, let's say, aggression or his tempo. And at that point, you can see Officer Burbank standing over Mr. Ellis from a distance of maybe 5 to 7 feet, right around there. And at that point, he deploys the taser into center mass into Mr. Ellis's torso.
Again, an appropriate use of force at that point?
At that point, yes.
Okay.
Yes.
Definitively at that point.
Yes, based on what's going on and all the ineffective rather force options that hadn't worked up until that point. You see the officers transitioning between force options, none of which had worked, right? And so now you're starting to scale up and go, okay, the lower force options have been proven ineffective. And when you take into account what we had talked about proportionality, or what Tacoma calls the controlled superiority principle, you have to come in at a level of force higher than what you're being met with in order to overcome that resistance. And so the taser would have been wholly appropriate at that point.
And the taser, of course, you saw the video, at least the first one, didn't work.
It did not work, and they often don't. I mean, they have, stats vary between 40-60, 50-50, but it's not uncommon for tasers to fail or to not work, largely for some of the reasons that we talked about earlier, the technology of it, how they work.
And is there anything that you saw or heard in the videos and audios that would be disconcerting for an officer at that point in time?
Yeah, we talked last time we met about the pain associated with taser deployments, and they're very, very painful. Having been tased multiple times myself, it's very painful. It's probably one of the most painful things that I've ever encountered. And so when you tase somebody and they don't react to it, sometimes they might not react because the taser didn't work, but when they ask for more or they challenge you, right? In this case, I think he said something like, "Do it again." That is, as a police officer, that's borderline terrifying, because it's pretty common when you tase that you can tase some big, tough, angry people, and they get very compliant very quick because it hurts bad, and they want nothing to do with that. Don't do that again. That's what you often get. Okay, I give up. But when you tase somebody and they say, "Do it again," like, to me, that is super, super concerning, because the person can either fight the taser or they have the pain capacity, threshold rather, to just eat that and keep going.
And then so you have then the second and the third use of the taser in this case, again, appropriate?
Yeah, because the first applications weren't. And it might be helpful to talk a little bit about, again, the technology of the taser and how it applies to this particular deployment.
Go right ahead.
So before, when we talked about when you deploy the taser, it basically launches 2 darts, and they're small darts about the size of maybe a number 10 fish hook, that gauge, if you fish, and they're barbed, and they're maybe 3/4 of an inch or an inch long. The better spread that you have, that is the greater distance between the 2 darts, the more effective the taser will be, because it incapacitates the person by administering electricity between those 2 points. So if I have a taser, for example, in my shoulder and then one in my calf, all of the muscles in between there are going to be interrupted and affected. So that's going to lock me up from shoulder to calf. The closer that distance becomes, the more it's a pain tool and not an incapacitation type tool. So we use the term NMI, which is neuromuscular incapacitation. And that means basically the person cannot move because the electrical signals between the brain and the muscles has been effectively hijacked by the taser. So the person's brain can't communicate with their muscles anymore. That causes them to, what they feel like, locking up. Practically, their muscles aren't locked. You can still move them and manipulate them, but the person getting the taser feels like they're locked up. If you just deploy the taser, say, 10 inches away or a foot away, like to the middle of their chest, what you would essentially end up with is some pretty severe ab cramping, or like torso type cramping. It might cause the person to really cramp up, but they're still free to move all their arms and legs. And so at that point, it's going to be more of a pain compliance tool than an actual debilitating tool.
And so when a officer tries to create distance between him and the suspect or the arrestee and using a taser, that's to make sure you get the spread, or at least attempt to get the spread of the darts?
Yeah, correct. Like the distance between you and I, which is maybe 15 feet-ish, that would be a good distance to deploy the taser. Because by the time, the taser is designed that one barb flies straight and one barb flies at an angle, and so when they come out, they spread. And I'm kind of overemphasizing the angle, but as the taser would deploy toward you, the darts would spread as they sail through the air, up until the point where they reach their maximum length, and they would just fall to the ground.
Okay.
But closer, if I walk much closer to you and I deployed it into your chest, the darts would be much closer together, right? And whether it hit you in the torso or the leg, it would just hurt really bad, but it wouldn't have a debilitating effect.
And so again, and the time between the tasers, is that appropriate in this case?
Like between the
First, the second, and then the third?
Oh yeah, yes. Because this is happening in real time, very quickly, and so they're trying to get Mr. Ellis under control, and so immediately out of the gate, when Officer Burbank tases Mr. Ellis, and Mr. Ellis says, "Do it again," right? So he tried it again, a third time. That didn't work. I mean, and at this point, your force options are narrowing considerably.
And meaning you're going to potentially get to the next level if it doesn't succeed?
Yeah, and if you've never had the challenge of physically wrestling with somebody, if you wrestle with someone for any period of time, it is exhausting. And so you don't want to spend minutes and minutes and minutes wrestling with people, you know, especially out in public where the circumstances are so dynamic and unpredictable.
So, and I guess the question is it rising, based on your review, let's say after the first two tasers that we know are unsuccessful, is it starting to get to the level of the potential use of lethal force at that point?
It's a really concerning event at that point that nothing had worked, including multiple taser deployments, that they were still unable to get him under control.
Okay.
And so it just depends on the circumstances, right? It just depends on what happens next.
And the officer's decisions made it under the stress at that particular point in time.
Yeah, correct. And then and what they're perceiving and things like that.
So obviously the third one, you watch the video, you see them get the situation, starting to get the situation under control.
Yeah, everyone kind of starts to tucker out.
Okay. And you recall him getting in cuffs based on the statements in the videos?
Yeah, eventually they were able to put him in handcuffs, right?
And again, appropriate?
Handcuffing him?
Yes.
Yes.
Hobbling?
Yes, although my understanding is that came later in the event.
Right, it did, but I'm not saying it at the same time.
Oh, yeah.
So, is the fact that he's in handcuffs, does that mean he's under control?
To a greater degree than if he were not in handcuffs.
Mhm.
Yes.
And what does that mean, though?
Well, just because someone's handcuffed doesn't mean that their freedom of movement is wholly restricted. I mean, I personally, I've been headbutted by people in handcuffs. I've been spat upon. I've been kicked by people in handcuffs. And so there's kind of two ways of conceptualizing control. There's like general control and specific control, right? And so if you have a person in handcuffs and they still have some freedom of movement, that means they can kind of dictate some of their own places where they can go or things they can do. That's what I would call general control. Specific control is where the person can only move according to what the officer wants them to do. And so, like for example, the most poignant example might be someone who is secured to a gurney, like a medical gurney. Then you're in pretty much complete control then, because that person can only go or do what the officer wants them to do.
And is it appropriate in the context of trying to get someone under control to put weight on their back,
Yes.
or any other part of their body for that matter?
There are very few other ways of doing it.
Okay. And what do you consider in looking at that?
As far as, I'm sorry.
What do you, as far as a person applying weight to one's back, and as far as your analysis going to seeing it's inappropriate, or finding it's appropriate, what do you concern yourself with as far as the application of the force, the weight goes?
Well, again, it's you begin with the question, what are they trying to accomplish, and is that legal? And if you satisfy that query, then you say, okay, is the force reasonable to try to do the legal thing they're trying to do? Okay, and with with all uses of force, it's very important to understand this. With all uses of force, police training necessarily addresses contingencies or suboptimal outcomes, right? And so, for example, if with OC application, or what you probably know as pepper spray, right? Where police officers are trained that if you pepper spray somebody, right, once you pepper spray them, then you evaluate them for their physical condition, right? Some people might have, a very small portion of the population might have an allergic reaction to it, or it might cause them respiratory distress. Now, you're trained to identify those things, acknowledge them, and then react appropriately. The same thing with baton use, right? And it stands to reason. You don't have to be an expert to know that if I strike you with a metal pole, it's probably going to cause some damage, right? The level of damage might depend on the intensity of the event. So if I strike you in the arm or the leg with a baton 2 or 3 times, you're probably going to get some bruising. Depending on the pace of the event or the intensity of the event, you may get a fractured bone. And so police officers are trained to look for those things too after a baton deployment. And you would react to those things. And the same thing goes within you're putting people in a prone position on the ground, right? You look at what you're trying to do, and then whether that's reasonable as far as how much weight and for how long you put on the person. And anytime you put someone in a prone handcuffing position, you're always trained to monitor them for respiratory distress or complaints, shortness of breath, those kinds of things. But that's just like any other force option that you have, is that you look at what you're seeing at the time, and then your training includes contingencies like summoning medical personnel, things like that. And so it isn't the case that because someone might have an allergic reaction to OC that you never use OC. That's not a training principle. Or because you may bruise somebody by striking them with a baton that you never use a baton. Or same with the taser, that someone might have an adverse reaction to the taser that you never use the taser. All these things carry with them the possibility of injury. That's kind of a truism when you have force events with the police. And so you're putting people in a prone position and placing weight upon them, you're trained to not put unnecessary weight upon them. And again, the concept of necessity is a reasonably effective alternative to what you're doing to accomplish the control of the person. It's very, very difficult to control somebody on the ground, especially someone who's big and strong and agitated, without the application of some weight.
And the timing or the length of time the weight's on, is that a factor you look at as well?
Correct. The amount of weight and the duration.
Okay.
Correct.
And did you, based on the descriptions you've heard, did you see anything, again, inappropriate in the context of how they gained control of Mr. Ellis?
I didn't.
Including placing weight on him?
No, and again, when you look at, even when they put weight on him, that wasn't wholly effective because he was still thrashing around and resisting. And so even with the application of weight, and then what's important also is that once his resistance ebbed, that is once it declined, they then reduced the amount of force they were using, right? And so in the case of Rankin, excuse me, that once Mr. Ellis stopped thrashing around, right, the amount of force being used then proportionately reduced, right, or necessarily reduced. They turned him on his side, and then when he started thrashing around again, they placed him back on his stomach. And so you see this modulation of forces that when the resistance gets more intense, the police response gets more intense. When the resistance declines, the police response declines. And that's how that's supposed to go.
And that's how you saw in this case?
Yes.
And what about if you hear, is there the training that you do when you hear a suspect or an arrestee say they can't breathe? From an officer perspective at the scene, what are you trained to do initially? Do you just accept that and stop struggling?
Well, you evaluate in the context of the event,
Mm-hmm.
right? And so their words are less important than the conduct, because people frequently, ever since Eric Gardner, you get a lot of people when you're trying to arrest them, they complain they can't breathe, or oftentimes, once people figured out that if they said they swallowed drugs, that the jail wouldn't take them, then all of a sudden everybody you came into contact with claimed they swallowed drugs. And even I would do surveillance on people for days at a time, and then once you arrest them, they would say, I just swallowed drugs. And you're like, I've been watching you for 3 days. You hadn't swallowed drugs. And so you have to evaluate these claims in the context of the event, right? And so it's not something that you ignore, but you pay attention in the broader context of what you're seeing.
And did you see, again, anything inappropriate here is how whatever officers heard these statements, that they did anything inappropriate in the use of force.
I didn't, especially in the context and the intensity of the event. It wouldn't be uncommon for everybody to be out of breath after wrestling like that for a while. And so even if immediately the person said, I can't breathe, you'd want to monitor that very closely and evaluate that claim. But also you're in the context of we just spent the last 3.5 minutes or whatever it is wrestling, I think everybody would be out of breath.
Give me one moment here, Your Honor. Your Honor, would it be appropriate to take a morning break?
Well, I was going to at 11 o'clock. It's 10:59. I can take our break now. All right, ladies and gentlemen, we'll take our morning recess for 15 minutes. Please do not discuss case among yourselves with anyone else. I'll ask you about that in front of the jury so they'll know you're done. And I am just not skipping you. Mr. Fricke, any further questions?
No, Your Honor, thank you.
Okay, Mr. Calavo.
Good morning, Mr. Nielsen.
Good morning.
I'm going to start with some questions on your background on this case. You were retained initially by Defendant Burbank,
Correct.
and you charged for your services in your review of the case.
I do.
And your rates back at the time when you were retained was $175 an hour for review, or for travel time, excuse me.
Travel time, correct.
Yep. And then you did $350 an hour for case review
Correct.
and $400 for depositions.
Correct.
And is that still the same rates as what you charged today?
For this case. But not for new work, but for this case.
And when we interviewed you back in March of 2023, you had billed approximately $30,000, is that right?
If that's what I said, that seems high for that time, but that's what I said.
What do you think you've built now?
Maybe if it was 30 then, maybe 35 now.
And you're actually paid from a legal defense fund for law enforcement
Your Honor,
officers.
objection. Move strike.
Okay. You prepared a report in this matter,
I did.
and you did that back in September of 2022.
I believe so.
And you were provided numerous documents from defense, and you included those documents in your report.
Yes.
And you reviewed all of those, correct?
If they're listed in the report, then I reviewed them, yes.
And you've reviewed additional materials since then, correct?
I have.
And you relied on all those materials in your analysis?
Most. Some, if they're included, I mean, I read them, but that doesn't necessarily mean they factored into the analysis.
When you reviewed subsequent materials, did it change your opinions at all from what you had documented in your report?
No.
And although you're an active law enforcement officer with Renton PD, you don't have any personal relationship with any of the 3 defendants here?
That's correct.
And you've never met with them individually?
I think not just me and them,
Have you met with the defendants?
briefly.
And when did you meet with the defendants?
It was a long time ago, maybe, I don't remember, 2 years ago, a year and a half ago?
Okay, so if you authored your report in September of 22, was it before that?
Yes.
So your opinions in your report includes the information from what you gained in your meeting with the defendants?
Not necessarily. It wasn't materially different than what I learned in the materials.
And I want to ask you some questions about your background in general. And you've been with Renton PD for how long?
Going on 13 years.
And I believe you told us in March of 2023 that about 80% of your work is Renton PD and about 20% is as an expert or a consultant.
Yeah.
Is that still accurate?
By time, yes.
And almost all of your work is done as a expert for defending law enforcement.
Mostly, yes.
And I believe you told us at your interview that you'd only opined against law enforcement in one of your almost 90 interactions and engagements as a consultant.
Yeah. In all fairness, though, I'm pretty selective about the cases that I take. So many cases are not defensible.
And you said, I think, the week before that you've testified twice as an expert.
I'm trying to think if there was a third, at least twice. There might be a third one, but at least twice.
And you're also on the Lethal Force Review Board for Renton PD.
That's correct.
And those cases have all been shooting cases.
Yes.
And
Yes.
and you found in favor of the officer in all of those cases.
Yes. In all fairness, there weren't many, but that's true.
And you're testifying today as a expert in police practices
Correct.
and use of force.
Correct.
You're not an expert in psychology.
I wouldn't say that. I mean, I would say correct. Sorry.
And you're not an expert in cognitive behavior
No.
or toxicology.
No.
And you're not published in any areas regarding use of force.
Correct.
And you also haven't conducted any research on use of force that's been published.
Also correct.
And you're not offering up a certified forensic video analysis opinion on anything?
Correct.
And when you did your analysis and what you based your testimony on earlier, you didn't actually go through a frame-by-frame analysis prior to writing your report.
I did not.
And you didn't actually go through and do any measurements or z-axis analysis.
No.
And you didn't do any video extraction analysis?
Correct.
You haven't had any training on motion blur or artifacts and in forensic video analysis?
Not, excuse me, not to the extent that I would offer that in court.
And when you were interviewed in March of 2023, you had essentially just made your conclusions based on eyeballing the video,
Yeah, I watched the video, sure.
but you didn't use any special tools or anything of that nature.
I did not.
You're also a trainer, or you were a trainer at the Criminal Justice Training Center,
I was.
and that was between 2006 and 2013.
Yes.
You've never trained any of the defendants in this case?
Not that I know of.
And when you've been a trainer at CJTC, you were there to train on courtroom testimony?
In part, but going back to your prior question, technically, when I taught SWAT school, that was under the auspice of CJTC, and I don't think we talked about that last time. I don't know if that doesn't really change things materially, but I think when I taught SWAT school, CJTC oversaw that, and that was after 2013, so that was probably 2015 to 2020.
And again, that didn't involve any of the defendants on this case.
Not that I know of.
And in the class that you did teach, it was for courtroom testimony?
At the CJTC, and there was some, it was at the end of their criminal investigations block, so there was some of that too, but it was predominantly courtroom testimony, yeah.
And so you're teaching officers the technique and for both direct and cross-examine on how to testify?
And I object as to relevance in this case.
You may answer.
Yeah, among other, and then just, many have never been in court before, and so just like the role, who's there, the jury and the spectators and the lower bench and things like that, yes.
And you've not taught at the CJTC other than the SWAT and courtroom testimony, you've not taught anything on defensive tactics?
That's correct.
And you've not taught anything on crisis intervention training?
That's correct.
And you didn't teach anything on de-escalation?
Correct.
And you testified earlier, you broke down some of the Graham factors which apply to the defendants in this case, and although the judge is going to instruct the juror, you went through the Graham factors, and those are pretty universal across the board for the United States.
Yes, that's a very fundamental use of force principle.
And with that, that's judged from a reasonable officer's standpoint, right?
Correct.
And although you testified this morning that you look at things from Officer Collins' standpoint and that he's a grappler and he takes that in with him, it's still a reasonable officer standpoint, point of view.
Yeah, they still have to act reasonably, and so, yeah, sure, I agree.
And if an officer is new to the force, that doesn't change the standards for him.
No, it's still reasonableness, correct.
And if an officer has limited experience out in the field, it's still reasonable, correct?
Correct, yeah.
And when they're assessing the immediate threat, it's not an indefinite amount of possibilities, right?
That's true, right.
So you have to look at an actual immediate, imminent threat that the officer is facing.
Yeah, and their perceptions under the circumstances, sure.
A specific threat.
Yeah, it can't be a theoretical threat, correct.
So just because someone's changing a tire iron and an officer comes up to or changing a tire with a tire iron and an officer comes up to him, that's not a threat at that point.
No, I mean, it's a concern, but you wouldn't obviously act on it, but you would attend to it, but no, I agree with you.
And you also consider the seriousness of the offense, right?
Correct.
And in your review on this case, the seriousness based on the video would be basically misdemeanors.
I don't know, I think people could disagree about that.
Well, in your interview back in March of 2023, you said it'd be resisting or obstruction.
Objection, Your Honor, unless it's shown to the witness.
Do you,
Well, let me excuse the jury for a moment. Ladies and gentlemen, please excuse us. Do not discuss the case.
to stay.
Maybe I don't, no.
Okay.
You guys can be seated if you want, but I mean, the problem here is, at what point in time? I mean, when one first encounters Mr. Ellis by if one credits the officer's account, he's in the street, maybe get into a car, where it may or may not be a felony, it may not be even a crime. On the other hand, there's a point at which it appears that, by the officer's account, Mr. Ellis has struck one of the officers. And there's another part at which he may have threatened the officers, in which case that could have been all be assault 3, which is a felony, right? So what are we talking about?
And Your Honor, that's why I specifically asked based on the video, and that was the question that we had to him at the interview. Based on the video analysis, it would be resisting and obstruction. And based on the officer's account, he said assault 3. But based on the video, what was on the video, he said resisting and obstruction. And you consider the seriousness of the offense.
Could we have a cite to the transcript, Your Honor?
It's 957, exhibit 957, page 133, 20 to 25. Says, based on the videos that we've just went through, did you see any crime committed by Mr. Ellis? And he goes, I think we gotta go back to this question about whose events you believe. I think that you could say that he was either resisting or obstructing police at a minimum.
Well, I'm not sure about the question. I think it's misleading to just limit this to the video, if that's what your question did. I didn't pick that up. Maybe you did put it that way in your question. I didn't pick that up when you asked the question. I'm willing to let you ask the question. Even in his answer, he's saying, well, it depends on what you credit here and what you don't. So he didn't necessarily agree in that deposition with that. And of course, we had the same thing, did we not, from Mr. Ryan, in terms of what account you credit. If you make this a little more plain that you're talking about something other than what the officer's description was, which he does appear to credit for the reasons that were discussed when he was being interviewed or examined by Mr. Fricke, then the question itself, I guess, would be fine as long as it's really clear what we're talking about. Any other comment from the defense?
Well, I agree with the court, Your Honor, because the questions are specific to the video. And he mentions taking her questions, and she's taking it out of context.
Any other comment?
Without context, like you just said, look at these videos, correct. So that's what she's referring to at that interview, nothing more.
Mr. Usher?
I think in all fairness, he qualifies even the response that Ms. Nicolava wants. He says, well, in that context, which is out of context, maybe we're seeing this, but as a totality, that's not what we're seeing.
Yeah, I mentioned that too. Anything further?
No, thank you.
Okay. So as I say, if you make that a little more plain, we can go there.
I apologize, Your Honor. I thought I said video. I'd have to go back through the transcript.
And maybe you did, but I didn't, and maybe I didn't pick it up.
I wrote it down. And I'm sure the court reporter has it.
Right. Well, in any event, still, let's be more specific. Otherwise, I think it's confusing. All right, let's have the jury back. And we can have the witness back too.
Judge, I'm gonna make a correction on one issue.
Oh, okay.
So, Ms. Nicolavo just brought up collateral source or funds in cross-examination.
She did.
I don't know what the purpose of that was.
What was the purpose of that?
There's a bias to it, Your Honor. You receive your funds just like you're getting paid from across the board.
That's not what you said, Lava.
I said he got paid by a legal defense firm, and he had to get approved.
Fund, you said.
Yes, legal defense fund.
Okay, so you didn't say by defendants. You brought
I
up-
didn't say defendants.
Okay.
I never said defendants. I said he got paid by a legal
That's
defense
kind of the
fund.
problem, isn't it?
Law enforcement defense fund.
That's kind of the problem.
Why would you bring that up?
I think it's part of what the bias is, Your Honor.
How's that biased? Who pays him? How's that biased? If, for instance, a defendant who was partially indigent and partially not applied to the court for the expenses of their representation to be paid by public defense, and let's say that was granted, so that an expert for witness, for instance, was paid, even though a privately retained defendant could have an expert witness paid for out of public money. It's possible.
That's not what this is, though, Your Honor.
I know that. I'm using that as an analogy to say, would that be relevant? To ask you that question. Would that be relevant for the jury to know?
I think that's comparing apples to oranges, in my opinion.
Well, answer my question as opposed to avoiding it.
No, I don't think that's relevant.
Okay,
because I
so now explain to me how it's apples and oranges. How does it not apply?
Because he's getting paid by a legal defense fund that is a nonprofit organization for law enforcement only.
And if he doesn't get paid by that fund, are the defendants not still liable for the expense?
I know he had to get approved by PORAC. The name of the firm is PORAC, and he had to get, or the fund is PORAC, and he had to get approved by them to be a witness.
Yeah, I sustain the objection because it wasn't relevant, and I think you knew that when you asked it.
I appreciate, Your Honor, that was not, I thought it was relevant as to bias, so. Court.
Yeah, well, I made my ruling because, for once, I think I'm right. But, you know, and the example that I used, I think, throws in fairly stark relief while I was right. Well, anyway, Ms. Fricke, you want to add something?
Well, I think the question's unethical. I mean, I think in every case, whether it's civil or criminal, those questions are not asked, and everybody knows that who's in practice in the courts of the state. So it wasn't designed to show bias. It was designed to prejudice the defense and Mr. Nielsen in front of the jury. That was why it was asked, and it was clearly inappropriate.
I suppose in civil litigation, you may as well ask, aren't you being paid by an insurance company?
Right.
Do you want to make another point or not, Mr. Conrad?
No, Judge, it's been made, and I hope that doesn't happen.
I hope so too. Okay. So let's have the witness back and the jury back. Someone will need to get to our witness for us. Okay, Ms. Nicolavo, continue when you're,
Thank you, Your Honor. Mr. Nielsen, before we left for the break, I was asking you if, based on the video evidence alone, when you're considering the seriousness of the offense, potential offenses, is it true that you previously stated saw resisting arrest or obstruction based on the video evidence alone?
If you represent I said that, then I said that.
Do you want to see the transcript?
No,
Okay.
I trust you to that, on that topic.
And we're just talking about the video evidence.
Okay.
Is that, sitting here today, you've seen the video evidence, that consistent with what your count is?
I have seen the video evidence, and the trouble I'm having is it just out of context. Like if I just saw that without any backstory, is that what your question is?
Yes.
Okay, I would agree with that.
And so when you're considering the seriousness of the offenses, that would be the seriousness of the offenses that you saw in the video.
Yeah, keeping in mind that's one of 3 factors, but yes.
Right. And then you talked about earlier the other factors, and that includes the immediate threat.
Correct.
And when you consider the immediate threat, you also consider things like the number of officers available.
Yeah, but to be clear, it's not immediate threat. It's danger to the officers and others. So I wouldn't use the phrase immediate threat.
So from Graham, you wouldn't use immediate threat language.
I mean, Graham contains that language, but broader. I mean, there's risk involved as well.
Right. And you testified earlier that those have to be specific risks, threats.
Yeah, they can't be theoretical. Sure.
And you testified earlier about, in fact, you said the officers have memorized the RCW for necessary force.
At the academy, they had us do that. Yes.
And when you look at the amount of force to be used, as you said, the force that's used has to be necessary. And then it's broke down into basically 3 different prongs, right?
Yeah, generally.
And you can, one of those prongs is there's no reasonably effective alternative.
Your Honor, I'm gonna, to the extent she get into the instructions that the court may or may not give to the jury, I think it's inappropriate line of question.
well, you asked him about some of this on direct examination. Let me grab my notes here.
So an officer may only.
Hold on a second.
Oh, I'm sorry, Your Honor.
Yeah, so on your directive this morning, some of this was, the word necessity was broken down into various aspects, so it's reasonable for Ms. Nicolavo to cross-examine about that. Go ahead.
So under the necessary force, you're looking at, you have to exhaust all other reasonable alternatives before you progress to the next level of force.
No.
No?
Correct. No.
And so that is the RCW 9A16010 indicates necessary means that no reasonably effective alternative to the use of force appeared to exist.
That is not what you said. So I disagree with your characterization.
You would agree that it includes necessary means that no reasonably effective alternative to the use of force appeared to exist.
Correct. And I don't want to mischaracterize that language. Appeared to exist is very important. What you said is that you have to exhaust every other use of force before you use the one you're going to use, and that's not true.
You use reasonable force throughout,
Yes.
and you consider alternative methods of force.
Yes.
And some of those alternative methods of force could be based on what you've been trained on
True.
and your skill set,
Yes.
and employing those when it's necessary.
Yes.
And you also agree, though, that when the threat ends, the force ends?
Yes.
Because when there would be no necessary force at that point when there's no threat.
Well, I mean, yeah, broadly speaking, when you get to the end, it has to be a legal thing you're doing, right?
Right.
That's the final component of necessity. It has to be a lawful act. That's the threshold, yeah.
You agree that when the threat ends, the force utilized ends?
You don't have to object to the characterization.
Well, I don't know exactly what it means either. For instance, we've already had some discussion that says if somebody's handcuffed, the threat level may be reduced, although maybe not eliminated. But even if someone's doing nothing, they're still handcuffed. So is that a use of force? It is, right? So the use of force is the handcuffing. So your question's a little too broad, I think. I think the gist of where you're trying to go is fine.
Thank you, Your Honor. I'll get more specific. Other than the handcuffed restraint, when the threat ends, you want to use additional force on the individual.
Well, it's hard to characterize it in those terms, because you could use force with a relatively low or minimal threat if you're trying to achieve a lawful objective. Like, so for example, if you said, "Come with me," and the person just sat there, that's not a threatening gesture, but they have to come with you. And so if you pick them up and put them in your patrol car, you could characterize that as force, but there was very little or no threat. Does that make sense?
Yeah. So, if someone is hogtied and handcuffed, the threat has ended, correct?
Yeah, there wouldn't be a threat, but that wouldn't preclude force for a non-threatening end.
So you would still think it's necessary and reasonable to use additional force after somebody is handcuffed and hogtied?
It could be. If they're thrashing around, banging their head on the ground or whatever, you have to moderate the force depending on the thing. And so you're predicating force on there being a threat. And in many cases that's true, but not in all cases.
And would you agree that when you use force, you have to consider the foreseeable effects of that force on the individual?
That would be the quantum of force that we talked about last time we were here.
The likelihood of injury to them and the risk of injury to the individual.
Compared to the government interest, yes.
And that has to be considered by every officer who's employing force.
Correct.
And you talked about controlled superiority principle. Remember testifying about that today?
I do.
And you also include that in your report.
Correct.
And the controlled superiority principle indicates that officers must always maintain a balanced, controlled superiority over the subject level of noncompliance.
Yes.
Right? But that still requires that the use of force be necessary.
Yeah, true, yes.
And it still requires that the use of force be reasonable
Yes.
and that it be lawful.
Yes.
And that it be no other reasonably effective alternative existed.
That would be part of necessity, yes.
And when you are determining whether use of force is excessive, you also you evaluate each individual act, correct?
I don't think, sometimes, if you want to break them down into like discrete acts, like for example gunshots, it doesn't always happen like that.
Well, for example, if you utilize an LBNR, you would evaluate that act, right?
Yes.
And if you utilized a taser, you'd evaluate that act.
Yes.
And if you utilize them together, you'd evaluate the act also collectively.
Yeah, you could for reasonableness, sure.
Yeah. And so if an officer is using an LBNR and another officer is tasing at the same time, you look at that as collective force.
Yeah, you could.
And you have to evaluate those individually, but also when they're being used at the same time.
Yes.
And the officer needs justification for reasonableness for each act of force that they use against a suspect.
Yeah, in the way that we talked about it here. Right. But it's not always the case that it's each individual punch, slap, or kick is like a discrete thing. But the way you characterized it with the separate force options, I would agree with that. I just want to be clear about that.
I appreciate that. I want to make sure I'm clear on it too for the collective force and each individual act. So when you have two officers at a scene, like you have Burbank and Collins here, you evaluate the reasonableness of their force together,
Yes,
the collective nature of it.
yes,
And when defendant Burbank comes on scene, you evaluate the collective nature of all three defendants in addition to what they do individually.
you may have misspoke. Did you?
No, wait a minute. Gonna have to excuse the jury for this. Matter of fact, let the jury take their lunch. Ladies and gentlemen, please do not discuss the case among yourselves with anyone else or investigate anything on any media or social media. Okay, and Mr. Nielsen, we can let you go. Now, it seems to me there may be differences in looking at a use of force from the perspective of what for training and for what use of force an individual law enforcement agency may be concerned about and so on. But for instance, as has been kind of talked about here a little bit, if one officer is holding Mr. Ellis and the other officer decides to use a taser, and let's assume for sake of this discussion that use of the taser under those circumstances was not appropriate, is the one who's holding Mr. Ellis responsible for the one who did the tasering as a criminal matter?
Your Honor, if they're working in concert with each other, if you have two partners that are working in concert with each other and working towards the same goal,
They're not accomplices now.
they're definitely looking at the collective, you're looking at the collective force of what's happening. And if I'm the officer that's doing the LVNR, and let's say that's justified, and somebody else comes in with the taser, and I'm seeing the other officer come in with the taser,
Yeah.
then you gotta bring it down. You can't have, okay, well, I'm gonna continue with the LVNR and then let him get tased. And we know from Defendant Collins' statement that he sees his partner come in to do the tasing.
Well, and the rest of the statement is that you released that LVNR, is that right, Mr. Crawford?
The first taser was applied when the LVNR was still, he was still in the,
Well, whether it's true or not, the matter of criminal liability, which is different than maybe civil liability, and/or collective guilt, are different. These are different issues here, and the state's been pretty loose about this, and I've mentioned this a couple of times before.
Your Honor, I will note that Mr. Fricke asked about collectively in his direct. He asked him
Oh,
specifically
well,
collectively.
sure. Collectively, there is certainly a concern about using, if there's 3 or 4 other officers already holding the guy down, there's no reason to give him a strike, for instance. So, I mean, in that sense, you look at the officer who did the striking and say you shouldn't have done the striking because that was excessive force in the circumstances of all the other things that are going on. But what you're trying to say is the person who did the striking is not responsible, but everybody else who was holding him down at the same time. That's not right. It's not the law.
Your Honor, I'm breaking down what defense asked on.
Respond to my inquiries,
That's what I'm
not to
breaking
Mr.
down- I'm
Fricke's.
breaking down what defense asked on direct, and that it's collective use of force.
You're using this in a leading statement kind of way, which is fine on cross-examination, but it isn't like you're trying to elicit a clarification from him. You're trying to advance an idea that the one officer who's holding Mr. Ellis is responsible for the guy who tasered Mr. Ellis, for instance.
Your Honor, I will note that Mr. Fricke asked about collectively in his direct. He they're working together for the collective force, working together for the same goal.
Look, you know, you're suggesting the use of force by one is the use of force by all, and it isn't the case in terms of the individual criminal responsibilities of any particular defendant.
So, just for clarification from Your Honor, where can the state go as collective force?
Well, you know, if this was a situation of an accomplice liability, that would be one thing. But you're not asking Mr. Nielsen those questions in a different way. So if there were two guys who were beating up somebody, we would say they're both liable for the assault if one's holding them down and the other guy's punching them. They're working in concert to assault somebody. Now, the state's made an argument here with respect to accomplice liability. And I'm not discarding that or discounting that, but you're asking Mr. Nielsen these questions as if that's not an issue, as if only the collective responsibility of these officers is responsible in terms of what is appropriate use of force or not use of force. And I say with respect to how a law enforcement agency might look at this in terms of what they want to do in terms of training or discipline or anything else, that's one thing. That may be of more interest to them. But and understandably so. But when we're talking about criminal liability, unless they're accomplices, I'm not responsible for for what somebody else does. Now, you might say, knowing that a taser was being used, is it still appropriate to hold somebody? If you put it that way, that would be fine, one way or another. But you're not putting it that way. Because now you're looking at it from the individual officer who's doing the holding. You're not saying the person who's doing the holding is liable for the act of the tasering. You're saying now you're liable for the act of the holding. Should you still be holding the officer? It's the,
Rephrase.
well, I would hope you do so and stay away from this again. Otherwise, this has come up multiple times. Mr. Osler, you wanted to add something?
On multiple occasions, unsolicited or responsive to Mr. Nielsen, has used the term hogtied. That's direct violation of the court's order in limine. I'm looking at my motion, number 2, the court granted exclude the use of the term hogtied, and the court said it should not be used by counsel unless introduced by the witness. This witness is not characterized as hogtied, and the state continues to do that in violation of the court's order.
I did say something like, look, I'm not going to edit the testimony of these folks. If the witness brings it up, that's one thing, counsel should not.
And Ms. Nicolava has done it repeatedly.
And Your Honor, we've used hogtie throughout the case. It's been introduced throughout the case. We've had it introduced with other witnesses. So this witness hasn't, that's how I've referenced it.
Well, if you think that there's reason to reconsider the motion in limine, the thing to do is take it up outside the presence of the jury. Not to say, okay, all bets are off, let's just ignore the court's order.
Your Honor, I didn't think I was ignoring the court's order. because
I
we've been
suspect-
Referencing it.
I suspect that in this instance, it was a reasonably innocent failure, but let's avoid it. All right. So, if you're going to talk about the use of force, it should be done in the understanding of the individual officer at a particular point in time, which may involve what other people are doing. I'll grant you that. If you want to say, assume for a moment that these people are accomplices in committing an assault, I mean, if that's the case, none of this matters. All the force is illegal. But, in which case, we're not talking about what a reasonable officer ought to be doing. A reasonable officer should not be using force gratuitously. No officer should. Okay, word break.